Hey everyone, Dan McKenzie here with the McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And thought I'd make a video about a topic that comes up in just about all of our estate planning cases, which is whether or not you should avoid probate. And I thought I'd give the reasons that I tell clients why they should avoid probate when I do tell them that. So thought, I'd start this video just with maybe a more specific disclaimer than I usually make, which is that this is very state specific, right? So I just mentioned I'm in Colorado. Colorado's got its probate laws. Every other state has its own probate laws. It's different. The standards for how you get into probate is different in different states, and then the probate process itself can be very different in different states. So in some states, it is more urgent that you avoid probate than in others. We've had a lot of clients come to us who moved here from California and are trying to update plans. Like everybody from California has a trust, it seems. I think avoiding probate in California is a much more a common thing than in some other states that we see. And in Colorado, really, I think the consensus among attorneys here is that the probate process is not necessarily so bad that everybody should avoid it. So I really don't tell everyone to avoid it. We do a lot of estate planning that, frankly, would require a probate process. So, I have another video about what probate is, and actually a couple different videos that might be worth you seeing as well. I will link to those in the notes. But anyway, so in Colorado, I definitely don't tell everyone to avoid probate. It is a court process. It is not fun. There is at least some bureaucracy involved, some forms you got to complete, some time you got to sit and wait for things to get done. It's usually slower, just like any court process. It usually takes longer than people expect. It usually probably is more expensive than people expect, honestly. There really is a court case. There really is a judge assigned. There really is a case number. There really is a file somewhere in a courthouse with your name on it if your estate's going through probate. So there's something going on there. It's not nothing. But in Colorado, and some other states, I think at some point the state legislature or the courts or whoever was kind of advocating for a change in rules realized that, we're wasting a lot of time on a lot of cases where everyone's getting along. Things are getting done smoothly. The personal representative is capable. They're taking care of things. They're selling the assets. They're accounting. They're doing what they're supposed to do. And why does the court need to be involved as heavily as it used to be? There really was a time, and like I say, there are some states where I think it's still true, that it truly is a court case where the people involved really are going to court and really are appearing in front of that judge and filing motions and having hearings and getting orders and having to do all that kind of stuff that you typically see in litigation. Well, in Colorado and some other states, we have what's called an informal process. I think in other states it's like a summary process might be the term. And what that is basically what the court wants to see now is they want to see the heirs get notified. They want to see the creditors get notified. There are some very specific things that need to happen to get that done correctly. But once they see that happen, they pretty much sit back. And they don't really do very much. We're not having hearings. We're not getting orders. I don't really go to court very often for my probate cases, to be honest. A lot of it is just paper, and now it's electronic, filings and stuff like that. So I'm not, you can see I'm not wearing a suit. I'm at work, and I'm not going to court today. So it's gotten somewhat rare that I do that. So once the court sees that those people have been notified, their position is, look, heirs and creditors, you have been told what's going on. You've been told where to come to if you have an issue. If we're not hearing from you, we're just going to assume it's going fine. And the court kind of sits back, and they're there to take complaints if there is someone who wants to complain. But again, it's up to the creditors and the heirs to protect themselves. The court really is not watching what the personal representative is doing. If the personal representative goes out there and sells the house, files the taxes, distributes the assets, pays the creditor bills, like all that kind of stuff, if anyone's unhappy with it, they need to tell the court. Otherwise, the court will just assume that all that stuff was done correctly. And at the end of the process, The personal representative does have to they have to make the inventory of the estate available to those people. They have to make an accounting of what they did available to those people. But at the end of the process, they just file a statement, typically saying, I'm closing this out. And I've done everything I need to do. I have resolved the creditor claims. I have distributed the assets. I have paid the taxes, and I am done. And the court doesn't check. They don't check to make sure that the house got sold for a fair value. They don't check to make sure that the taxes really got done correctly. Again, they are assuming that if anybody was unhappy with it, they're going to hear from those people. And so, for that reason, that's why I think I and most other Colorado attorneys are not necessarily telling everybody you have to avoid that process. Sometimes, a lot of times actually, it goes just fine. And we've had other situations where people did stuff to try and avoid probate, and frankly caused more problems than they solved. It would have been easier to just go through probate. We've had trusts that administrations that were very difficult. We've had designated beneficiaries who were pointed in the wrong directions. We've had people put kids on assets, so that the kids would just receive them as co-owners when people passed away. And frankly, again, it's caused way more problems than it solved. So before you run out and try and do any of those things to avoid probate, you probably should just make sure that that actually is really important for you, and that the stuff you're doing to avoid probate is not just going to cause more work than probate would have been. So I do start to tell people to avoid probate in basically 3 situations. So one is if you have a blended family, where you have like stepkids, because in a lot of those situations what happens is the married couple who is making the plan wants to ensure that they are taking care of each other. No matter who passes away first, the survivor gets to maintain their lifestyle, stay in the house, keep taking the vacations that are kind of similar to the vacations they've been taking, keep driving the cars, like all that kind of stuff. But ultimately, when the second person passes away, usually both people want to ensure that whoever passed away first, their kids are still going to receive what they would have received if it had gone the other way around. And so to do that kind of multi-step process where we're controlling things out a few steps rather than just giving stuff to somebody and hoping that they will do what we wanted them to do, that usually does involve some trust planning. So that blended family is one. Number 2 is if you own property in multiple states. You do have to probate everywhere on your own property. So like if we have a person here who's in Colorado and they, this is where they live, they have their house here, their assets are typically, mostly here, but then they have a vacation home like in California, for example. We are going to have to also open what's called an ancillary probate process in California to probate for that, and Colorado courts don't, they don't control real estate in California. So you can end up in situations where you've actually got multiple court processes going on, and sometimes that can be a little bit more difficult to get your arms around if you're the personal representative. So that's number 2. And then number 3 is if you have a, what I say, if you have a family member who would use a court case to torment your other family members. What I mean by that is, like I said, it really, probate really is a court case, right? There is a case open, and what that means is that if there is somebody out there who wants to be difficult or make a nuisance of themselves, they have a very easy avenue available to them to do that. And so when the court case is open, all they have to do if they want to kind of gum up the works is file an objection in a case that already exists. And that's pretty easy to do. I've seen handwritten objections that get filed. A lot of this stuff, the probate courts, they try and be available to people who don't necessarily have the funds to hire an attorney, because people do just get thrown into that process whether they are wealthy or not. Sometimes other types of litigation, it's like, look, you wouldn't even be in this case if you didn't have a lot of resources. Probate is not one of those situations. We can end up with such people who have very limited resources and really do need the court's supervision or involvement or whatever. So the courts, will kind of give some grace to people who are doing filing objections, even if they aren't real, really adhere to the rules quite correctly, or are a little bit outside what a lawyer would do. So it's just very easy. It's a small filing fee. Right now it's $12 to file an objection in a case that already exists. You don't, like I just said, you don't really need a lawyer to pull it off, and now you've caused a lot of problems. So if you've got a person out there who would use that process to really make things difficult for other people, you might want to consider avoiding probate. because if we avoid probate, people can still complain. They can still complain about all that stuff I mentioned earlier. They can still complain about trust. They can still complain about designated beneficiaries, but it's a lot harder. It's a lot harder for them to figure out what's going on. Those are usually done somewhat privately. They don't necessarily have the right to get information about what's going on, and then they do have to file a lawsuit because there isn't one already going on, right? So they actually probably have to get a lawyer. The filing fee is not $12. It's usually a few $100s. So right out of the gate, it's just a much bigger deal for those people who want to use the court system. They really got to be a little bit more dedicated than if they already have a probate case available to them. So I have a lot of clients who don't have any of those three factors and still choose to avoid probate. They just feel like, you know what, I just want to keep my stuff private. I don't want my family having to go to court, even if it is usually a simple process. You know, so lots of people choose. They just want to feel like, you know, non-probate planning or avoiding probate, I should say. They feel like they're a little bit more in control of things, and that probably is true. We don't have this third party out there that doesn't know us coming in and kind of potentially getting involved in our affairs. So lots of people, like I say, don't have any of those three. But if you have those three, that's when I really start to tell you, you know, let's look into ways that you might want to keep this out of court. So hope this helps. Again, if you're in a different state than Colorado, you absolutely should look at do a little bit more research into how hard the probate process is in your state and whether there's different factors there. This video might have given you something to think about. And if you are in Colorado and would like to speak with us further about any of this, we're happy to do it. Again, we are the McKenzie Law Firm. We are at 303-578-2745, and our website is themckenziefirm.com. And thanks for watching. I hope this was helpful.